recording today is going to be their, sorry to speak lawyerly right now, but their intellectual property. We're all pretty much by now familiar with the Zoom platform. So if people have questions, comments, please feel free to place them into the chat. Also, if you have questions during the practicum, feel free to raise your hand either physically or use the feature that's under the participants tab in Zoom so that we can call on you. Jen is going to lead off and speak for about 10 to 15 minutes or so, followed by Heidi. As most of you already saw, there's a slide deck that they'll be sharing. And then we want to leave the last 10 to 15 minutes or so for Q&A and comments. So Jen, please, and if you want to give a little more background information about yourself as a divorce attorney, please feel free to do so.
Thanks, Jeremy. You know, I think I'm just going to get right into it because we have about 20 slides. Heidi, do you have the slides up?
I will right now.
And then you'll move them forward if I just say next slide.
Give me, yeah, just give
okay.
me ready.
Sorry, guys.
All right.
So let me just say just a couple of brief comments. First of all, Heidi and I are really excited to be able to speak with you guys this morning through this virtual webinar about what I think is a really interesting and timely topic that sort of spawns from this collective experience that we're really all having, which is encouraging us as advisors and practitioners to be more creative in assisting our clients to not only resolve conflict, but to really explore alternatives and solutions for them as they are, as individuals may be experiencing difficulties or life changes. And our court system, as we know, is virtually closed except for 2 emergencies, and certainly once they open, we're anticipating that there's going to be long backlogs and delays. And so how can we be more solution oriented for our clients? USA 500 has been great in terms of pivoting for all of us to allow us to reach audiences and share information that is collaborative and helpful for all of us as we're all trying to kind of manage our clients and manages our practices. As Heidi and I were sort of preparing for this, we talked about sort of what we were trying to accomplish. And usually when I'm either teaching or lecturing, I always like everyone to come sort of with one main takeaway. And I think for me, at least for the areas that I'm talking about, what I want you to keep in mind and the primary takeaway for me is that both married and unmarried individuals can create contractual rights within their relationship that can be enforceable and that are valid if done correctly, which hopefully might reduce conflict for them. So I'm going to start just with a brief overview of postnuptial agreements, what a postnuptial agreement is, their enforceability in Massachusetts, and when you may want to think about sort of suggesting a postnuptial agreement to a client as opposed to some alternatives that might be available to them.
Jen, can I interrupt you for 1 second with a question?
Yes,
because,
I know can't see any slides.
I think there are a lot of lawyers in who are watching, but also some who aren't. And I know you referred to postnuptial agreements and, on the one hand, which is what we're talking about, and also the validity of agreements between married and unmarried people. Do you want to just clarify that they're not sort of utilized when people are not married and what that contract difference would be?
Sure. So there's a case, Wilcox versus Trout, and I can certainly email, you guys can, I can send you, I don't know if there's the chat link, I can send you that case, but that's really the seminal case that talks about unmarried couples' ability to enter into contractual rights. Very different standards than when we're talking about postnuptial agreements and married couples who have already been bestowed, for lack of a better word, marital rights and sort of the higher fiduciary and fidelity responsibility that comes with postnuptial agreements as opposed to Number one, unmarried couples, and then also prenuptial agreements, which we're not going to really get into today, but prenuptial agreements sort of being a different standard. Postnuptial agreements are a different creature, and we're going to go through some of the standards of those and what the court's going to be looking for in terms of scrutiny and factors that that you're going to want to be thinking about as you are drafting these kinds of agreements and undertaking them, in connection with whatever issue it is that is propelling that kind of an agreement for your client.
Perfect.
So postnuptial agreements. So do you have the slide up, Heidi?
Yeah. Yeah.
How do we do that? So unlike a prenuptial agreement, a postnuptial agreement, or otherwise known as a marital agreement, is obviously entered into after the parties are married. For those who plan to continue their marriage, confirming what their legal rights and obligations are. And these legal rights and obligations are typically, in the realm of financial obligations, whether we're talking regarding assets, certain assets, alimony. Postnuptial agreements, as a matter of public policy, are not going to be addressing anything related to children, custody, child support, child-related provisions. Our court, both in the context of prenups and postnuptial agreements, certainly have been very clear about that. So until about 2010, how do I go to the next slide? Until about 2010, it was uncertain whether postnuptial agreements in Massachusetts violated public policy and would be enforceable. And then in 2010, the SJC really sort of squarely addressed this issue for the first time and confirmed on a case of direct appellate review that these kinds of agreements could in fact be enforced, provided that certain criteria were met. And the Anson case, I won't go into the facts, but it was interesting. It was a long-term marriage. The parties entered into a postnuptial agreement a few years before the marriage, particularly to address a complex real estate holdings that the husband had in Florida with some uncertain value that was attendant to them. And the parties obviously were experiencing some marital strife. They wanted to stay together. They did, in fact, for a few years. Then the marriage further broke down, and the wife challenged the prenuptial agreement on the ground that it was inherently coercive and that it encouraged divorce. And the trial court said, no. The way this postnuptial agreement was executed, it was valid, it's enforceable. And it was a divorce case. They entered the divorce trial judgment consistent with, in a bifurcated decision, what the postnuptial agreement had provided. Could you just go to the next slide? So in affirming the trial court, the SJC basically said, look, a postnuptial agreement does stand on a different footing than a prenup and a separation agreement, insofar that it's a higher standard of review. These are parties that are already married. They have a heightened duty to each other. That doesn't mean they're not enforceable. They are enforceable, but we're going to look at them and drill down into different factors with more scrutiny and with more care. So in order to be approved or sanctioned by the court as enforceable, there are certain criteria that we're going to look at. And one of the most important criteria is asset disclosure. In the Anson case, there was sort of a placeholder set with respect to what the Florida assets and real estate holdings were. And the wife really latched onto that and said, I didn't know what I was signing. As a result, this postnuptial agreement is not valid. And the court said, no, you knew enough. You had you met with your financial planners, you had discussions about it, you were aware of it. The asset disclosure doesn't need to be exact or precise. It needs to be approximate. And as long as it's approximate and there's, general information provided in terms of market value, annual income, what someone may receive in terms of future ability to acquire income and assets in the future, we're going to say that the asset disclosure is complete. They also talked about the burden of enforcing these kinds of agreements, which is going to be on the spouse looking to enforce the postnuptial agreement with the standard of a preponderance of the evidence, which is sort of, a heightened level of standard. And again, the reason for that being is that the court really wants to make sure that these kinds of agreements are held to a higher standard. Throughout the theme of the case, counsel for consultation for both parties is sort of echoed, you know, really in the beginning of the case, the middle of the case, the end of the case. Consultation, counsel, a really important part of advising your clients when they are entering or considering these kinds of agreements. Duress and the need for the absence of fraud and coercion. You know, the timing of these agreements, how long there was negotiation, was there a negotiation? These are all really fact-specific cases and information that the court's going to be looking at. There needs to be waivers, explicit waivers for both parties, particularly in the context of a postnup as opposed to a prenup, where the parties are already inured with certain marital rights, and they're not only waiving those rights, they're waiving future rights they have. So the court's going to be looking for very clear waivers by both parties. And then really the bulk of the agreement talks about, you know, the concept of fair and reasonable. And fair and reasonable, you know, being a two-prong analysis, both fair and reasonable at the time it was executed and also enforced. And, you know, until we had Anson, we didn't know whether the fair and reasonable standard that we see in prenuptial agreements was going to be applied for postnuptial agreements. And to a large extent it was, but it was also enhanced with very specific criteria or factors that the court was going to be looking at in terms of fair and reasonable at the time the agreement was executed, and also fair and reasonable at the time that it's enforced. And the enforcement piece is interesting because what the court said is, in addition to all these other factors that we're going to look at, which is, you know, what was the objective of the agreement, what were the context of the negotiations, what's the complexity, what's the background of the parties. We're also going to look at Section 34, which is our property division statute. And although the postnuptial agreement does not have to mirror or look like what a Section 34 division asset is, certainly we're going to look at that as a barometer for you know, for what the factors are that the court is going to look at. So that was sort of an interesting piece of the second prong, which we don't see when we're dealing with prenups. So when we're looking, oh, sorry, Heidi, can you go to the next slide? So when to consider postnuptial agreements, I think that most of us, you know, consider sort of the classic scenario where there's marital strife, there's divorce looming, and, you know, we're advising our client that, you know, if you're not ready to get a divorce now, or you're not ready to move in that direction, what about the idea of a postnuptial agreement? But, you know, as a matter of course, there's lots of other circumstances where a postnuptial agreement is applicable and where it could be useful to your clients. You know, I have a case right now where the parties are relatively young. There is going to be a receipt of a substantial inheritance that neither party had anticipated. They didn't enter into a prenuptial agreement. They're happily married, but now we're going to enter into a postnuptial agreement in order to protect that specific kind of asset that might be coming in. We also have, you know, situations where we might have legal difficulties between the parties, you know, legal difficulties that one of the parties has, or financial difficulties such as bankruptcy, where we want to protect, or we want to try to insulate the other spouse. Protection of business interests. You know, you may have a case where one of the parties has an interest in a privately held entity, and the other partners are requiring that there be some protections regarding that partner's interest in the, you know, as opposed to the other spouse. We might have a liquidity event, a sale of an asset or a business, and we might also have some sort of changes in life circumstance. I have an interesting case right now where the parties are 80. And they don't necessarily want to get a divorce, but they do want to live separate and apart, but they want to have some certainty or protection in the event that at some point they get a divorce, or that they could just live comfortably long-term separate, and have some parameters regarding what those rights, you know, what their rights and obligations are, or sort of how they're going to be managing things and how they're going to be managing their life. Religious reasons, sometimes people don't want to get divorced for religious reasons, so they will often consider a postnuptial agreement to provide certainty to their situation. If they've had a prenuptial agreement that needs to be amended, or conversely, if they didn't have a prenuptial agreement and now they want to have some certainty because they didn't have time to execute that prior to the marriage, we see that very frequently. So lastly, I just want to talk a little bit about the next slide, which, and Heidi, I would be sort of curious to see sort of when you're working with your clients, if this comes up, the idea that, does the postnuptial agreement provide benefits? And I think one of the things that they talk about in the Anson case is that postnuptial agreements can actually have the benefit of inhibiting dissolution, of protecting interests of children from prior marriages and relationships. In certain cases, such as this elderly couple that I was just talking about, it can allow for a permanent separation without the turmoil and without the cost and time of a protracted divorce case. For those kinds of folks, it can create economic certainty for them. So if you have a case where one party has access to all of the resources and that's creating conflict within the marriage, we may want to shift assets to the other spouse so they have some control and ability to access liquidity and resources, which could have been a source of discord within the marriage. It can certainly create and define clear expectations between the parties. And lastly, if in the event that it is a precursor to divorce, it certainly can then create an efficient path to separation. In the Anson case, the postnuptial agreement was bifurcated, which means that the court addressed the issue of the postnuptial agreement first, which then allowed the rest of the divorce to sort of resolve itself in a more collaborative manner, because the assets, the resources, those issues were already predetermined as a result of the postnuptial agreement. So I think when we raise issues with postnuptial agreements with our clients, usually the reaction is, what is that? And the second reaction is, oh, I don't think my spouse is really going to like that, and they're going to be very offended. But I think if you think about really what a postnuptial agreement can offer, and now what we know the court has said about their enforceability and the value that they can hold, I think particularly given the time period that we're in, where folks don't necessarily want to undertake a divorce, or they don't necessarily want to get into the court system, or they can't, it certainly can be, a beneficial option for them. Heidi, do you?
Yeah, no, I mean, I think that's absolutely true, especially in these times. I mean, I think it's always, love and money, always tricky to talk about it in the same sentence. And I think that's true with prenups and that's true with postnups. But I think that in these times, we have this advantage almost, if you want to see it that way, of the courts being closed, which is, no matter what you want, it's going to be a long time before you get into court and have a judge sort of rule on anything. So how are we going to approach what is obviously a point in your marriage that's requiring some intervention for some reason? I mean, they're talking to you they're there for a reason, right? So I think I found people to be more receptive to this idea than maybe historically. I don't know if you've found the same thing, but I think
I have. I mean, probably I've done about 5 to 8 postnups, over the last 10 years, and we're in the process of doing 2 or 3, which is a large amount of postnups compared to prenups. Prenups are obviously being tabled right now because weddings are being canceled. Right. And so everyone is sort of deferring everything to next year. So I think that I've seen a real shift in sort of the curiosity about what a postnuptial agreement is and what it can sort of offer to the parties.
I did have a prenup this year that turned into a postnup, which was really interesting because they just
happens
couldn't get married. They couldn't wait to get married. And then, lawyers were sort of tearing their hair out. But, they were very, very sure about what they wanted. And they felt like it was a formality. But they also, this was a second marriage for one of the parties and a first for another. And the man who was his second marriage, had kids from the first, and he wanted to, there were a lot of complexities in it, and there were lots of reasons to have it, but he wanted to get married, and he was nearing 80. So, he was
Heidi,
time. Yes.
I'm sorry to interrupt. I just, as sort of the timekeeper here, I want to make sure
Yep.
we have time to get to your slides
Okay.
and also have some time for some Q&A, because we're gonna try to finish out around 10:45.
Okie doke. Then I'm going to move us on to the next slide and thank Jen so much
Yeah,
for
thank
what
you,
was
Jen.
just such an informative and concise and clear presentation on post-nups. So I guess my piece of this is really talking about how Jen, talked about how the courts are virtually closed, and in many instances really are closed to clients. What are alternatives and what does it mean? In mediation, which has always been an alternative or another process that people can use toward divorce, has become an even more sort of heightened process that can be used by people and should be used, I think, as a way to try to help the process move forward. And there are some things about divorce, about remote mediation that are exactly like live mediation, and there are some things that are distinctly different. So mediation always occurs with a neutral party being the mediator, and that person's often a divorce. Hopefully, I think I and Jen would say during a divorce, it would be a lawyer, but doesn't necessarily have to be. But it's someone whose goal is to try to get the parties to agree, try to get them to consensus, to an agreement so that they can move forward. And the parties can participate in mediation with the mediator, with or without legal counsel, present or sort of in the sidelines. And consult with them, when they're not particularly in the mediation itself. It's a private forum, and it's really important that people have equal access to financial information, or it's not a good forum for if somebody feels like assets are being hidden or there's not a full disclosure, then mediation isn't going to be a good forum. The other time that mediation really, I found, is not a good forum, and I think Jen would agree, is when one person is more controlling in the dynamic, the other person is more intimidated, and they really feel like they can't speak and sort of really participate in the mediation in a way that they feel heard. And I've sort of had a dynamic in a mediation where that was the case, but they were proceeding along. It was a highly litigious case, and I've been called in to mediate partway through. And we had started in person, and this became really aware, it raised my consciousness when we had to move to a remote mediation forum, and the dynamic really changed. And it caused me to consider, like, what is it that's really changing here? And why does this feel so different about this dynamic that was so sort of explosive when we were together? And now I sort of feel like it's all tamped down. And I started thinking about it, and there were two things that sort of came to mind, and I guess I've just been exploring and wanted to share with you. And one had to do with the technology that we were using, and Zoom or any other sort of digital video conferencing, and the other was the psychology and the physiology. So in the course of my sort of thinking about this, I was reading a book written by a gentleman named Nick Morgan called How to Connect with People in a Virtual World. And he talks in this book about this really interesting, reality, that when video conferencing was being developed, in order to create enough bandwidth, they had to reduce the Hertz frequencies. And I am not an engineer, but I get this concept that, they had to eliminate something in order to create sort of the forum for video conferencing. And what they eliminated were something called undertones and overtones of people's voice. And that's really the signature of someone's voice. It's what allows me to say, oh, that's Jeremy calling, or Jen, or my mom, or a grandfather, or a child. There's something about the voice itself that is very distinctive, and that is effectively someone's vocal signature. And that's different from sort of the tone of voice, but it's something very distinctive and sort of hard to put your finger on. And it's in that bandwidth that we don't get in video conferencing or FaceTime, or even, certainly in a phone. You miss those tones. So what does that mean? You lack the emotional clarity that you usually get in person. You also don't have all the other cues that you get when you're together, reading other people's body language, hearing those undertones, seeing people's facial expressions really distinctly, even people's, the way they move or the perfume they're wearing, or all of the things that are our senses that can sort of be picked up on in an environment physically when you're together. You miss when you're in the virtual communication sphere. So how might trust and emotion translate in typically highly charged exchanges between people who know each other very well, was the question that I kept wondering. Because usually when you're working, you value those in-person connections because you're trying to sort of suss out, is this someone I can trust? Is this a deal I want to make? All the sort of information that you gather when you're on an in-person meeting, you miss out on a virtual communication. However, when you're working with people who've lived together for 10, 20, 30 years, not only do they have all that information and know all that information, but they use it sometimes destructively to trigger each other. They know what's going to irritate each other. They know sort of what buttons to push. And when you move into the virtual sphere, you eliminate or at least reduce the ability for people to do that. So that emotional muting became apparent to me that sort of emotional muting was an advantage in some circumstances. When someone screams or cries or yells, you're alone in a room. It just doesn't have the same impact as seeing the impact on your spouse when they're crying or when they say they need to leave the environment. So people can harness their emotions better when they sort of need to employ the logic of their brain and remain more focused. And that certainly became apparent to me during the process when I was working with this very sort of implosive couple. So that caused me to ask the next question, which was, what are the psychological and physiological underpinnings people experience in a divorce, and how do they play out in a virtual context? Because obviously people bring to the table all sorts of things that are not just the logic and the reason that you want them to have when you're helping them negotiate an agreement, but they have a lot of other sort of things going on in their body. So I found this sort of valuable lens for thinking about this in the polyvagal theory, which I think is a really interesting way to understand sort of how people's heightened sort of physiological activity can inform what we as lawyers do when we're sort of working with people who are in sort of a heightened state of emotion. So we all have sort of the 24/7 danger radar that we hear of as fight and flight and a few other elements, but and that sort of comes to bear in part of this conversation. But before I get into sort of the details of that discussion, I'd like to talk about sort of how it plays out in these two polarized truths that occur. One is that divorce tends to be experienced as a dangerous situation. So that midbrain takes over. We run for safety, whether that's fight, flight, submit, freeze. That's sort of what happens to people often in divorce. When people don't get you back the financial statement, it's not necessarily because they don't want to do it. It's because they're paralyzed from doing it. Why? The other thing that lawyers expect and that you need to have happen is that decisions need to be made at every step of the way using all parts of your brain for the long-term benefit of yourself and your family. So you need people to be able to employ all those logical skills that they can't employ when sort of they're in that state of heightened arousal. So there's a man named Stephen Porges who developed this polyvagal theory, and he talks about blue zones and red zones and how, and sort of breaks it down as a way to distill that understanding. And I think it's a helpful way to try to reconcile the remote mediation question. So blue zone tools are what you need when you're mediating. You need to be able to communicate and connect in order to engage in constructive conversations and constructive negotiations and for mediation to be effective. what are the skills that typically are used to make that happen? The blue zone tools: talking, listening, facial expressions, tone of voice, body language, and touch are all identified in those as those blue zone tools. What happens with virtual communication is we lose 5 of those tools and we sort of have 1. So we lose, we keep talking, but we don't necessarily hear each other quite the same way, because the substance and the clarity that we talked about, sort of losing that empathic piece of it, isn't there. But the logic piece can be, and the question is, can we pull it into high relief through PowerPoints or other visual presentations during a virtual mediation, to sort of bring to the forefront what we're trying to accomplish? So using it as a tool, and maybe not, hopefully at some point post-COVID-19, it can be a tool, but not the only tool, because there are times that I think you want the emotion in the room, and there are times that you don't. So sort of when you dip into this sphere and when you don't, if you can do it electively, is obviously ideal. But right now we're sort of trying to harness it as best we can. And one of the ways that I think you can do that is through using PowerPoints or other ways to sort of point out what you really are trying to express when the words aren't quite enough. So I alluded a little bit earlier to what the red zones are, and fight and flight, submitting, collapsing. Those are all things that sort of people default to when they feel that danger coming on. So what does remote mediation give us that's so different? It gives the mediator tools that they don't otherwise have in person. The mute button, the raised hand button, thumbs up, time's out. It keeps the mediator has the ability to really control a dominating party from dominating. In that instance I talked about earlier, I said at one point, when the husband in that case was really, trying to dominate the discussion, I have a mute button, you have a mute button. I don't want to use it. I'm sure you don't want to use it, but I will if I need to. So he heard it, and he didn't want to be muted. So it was a way to just sort of, without really using it even, say that we can do it, but it protected the wife in that instance from being talked over. And it allowed her, another thing that she used at one point during it was just, I don't want him to see me right now. I'm going to take myself off video. I want to say what I want to say, but I don't want to be seen while I say it. I don't want to see, him be able to respond to my facial expression. Very interesting that she could sort of employ that tool during a remote mediation, and very effectively for her. So this is sort of a side-by-side on red and blue zones when you're trying to connect. So I'll just walk you through these skills that we talked about earlier in terms of talking, listening, all the things that we need for connecting, and the alternatives that we can use in order to get there.
Heidi, if it's okay,
Yes.
do you think we could go to Q&A in a minute or two? Is that okay?
That's absolutely okay. I was trying to
Great.
see, I'm sorry, I think the slide's actually stuck at a place here. So it's probably a great time to go to Q&A. And I apologize if, I think all the slides are in the share that I gave to you, but I'm somehow struggling a little bit to get to that end piece.
Well,
And,
terrific. Once we go off share, if people want to raise hands, put comments or questions in the chat, that would be terrific.
Okay, I'm going to stop sharing now.
Heidi, I have a question.
Sure.
I don't know how many sort of Zoom or virtual mediations that you've done up until this point, but if you had to identify just sort of 1 or 2 key differences between in person, for those people that are doing mediation right now, sort of the key takeaways for Zoom versus in person. Can you just give like a couple of key takeaways for people that they need to keep in mind when they're sort of dealing with these dynamics?
Yeah, I mean, I think, it's obviously, you always want to have an agenda when you start a meeting, but I think that with the remote mediations, I have found deploying that agenda to everybody beforehand and really sort of sticking to it, even in a time sequenced way, letting people know we're going to spend this much time on this issue and this much time on this issue. You know, if we can't resolve it, we're going to table it, because you have a sense of, you know, how long something should sort of take. And I think that sometimes people can sort of exploit the remoteness of a situation to just sort of talk around and talk around and talk around. And I think if people know that there's a tight window on this, we're not going to, we're not going to sort of abuse the medium by just sort of going on and on and on, because we're going to have to table that topic. Okay, we're going to table it. We can come back to it next time. But right now we're going to move on to the next issue. I think that's really useful. I think I actually am a real fan of the hand up thing feature, even if people don't ultimately use it as time goes on and they just use their own hand. I think it makes people think about what their contribution will be. It lets someone else know that they should sort of wrap up what they're saying. They can see that somebody else has something to say without actually interrupting. And otherwise it can sort of be a fight for the floor. And I think it's useful for people to be able to say, okay, I see somebody, the mediator can say, I can see, you know, Susan has her hand up and I'd like her to speak now. And I think that's a really useful thing. So those are two of the.
That's good to know. That's helpful.
Heidi, do you see the question from Tiffany Bentley in the chat? Or if not, I can read it to you.
I
Tiffany
just
can
am
say it
seeing
herself.
it now. Sorry, I wasn't looking at the chat actually. Let me read it. Okay. That's really interesting. I have not used the mute button when I've had counsel, if that's what you're asking. I do think, though, that the hand is useful still, for the same reason, I guess, that I said before. Breakout rooms, I guess I think that if breakout rooms are fantastic, I really, really like them. And I think I have used them when people just want to basically do a shuttle diplomacy for a limited period of time. Everybody sort of has to have a good enough facility with the, with Zoom to feel comfortable doing that and to put it on a time. I think that's the other thing that's useful is, so someone doesn't feel like only one person wanted to use that time and now they're taking forever. But if you say we're going to break out for 10 minutes and then we'll meet back at, and then you sort of can run the clock. And I think that's useful.
Heidi, I'll ask you a question, which is, with USA 500 clubs in multiple states, do you see the virtual mediation and divorce, meaning that divorce mediators could be cross-border? I mean, if this state, or when you said at the beginning that it's helpful for the mediator to be a lawyer, do you really need to know? Does the mediator really need to know the divorce laws in the given state to properly be able to mediate in that state?
I would say yes. Jen, can speak to this as well. But I mean, I prefer. Look, I'm a lawyer, and I'm not. I may advise people on the black letter law, for instance, in a mediation, sort of give them the outline, but I always want them to have outside legal counsel when I'm mediating so that they can be advised on the particular advantages and disadvantages of a particular agreement that they're making in mediation. I just think that's a much more, that's an intelligent way to approach it. I think mediators who don't want lawyers involved, I would be suspect of those people. So I guess the answer is, although I think I could facilitate a mediation that was not in Massachusetts. I'm not licensed in any other state, and I certainly wouldn't want to advise anybody on the law outside of Massachusetts. Jen?
Yeah, I mean, I certainly think mediation just surrounding conflict resolution, in general, conflict resolution mediation can kind of spill over into lots of different areas. And so that's a different animal, I think, than directed mediation to achieve a certain contract. Obviously, this is a contract that ultimately they're getting to, usually with you, Heidi. I think it's very, obviously it's state driven, but I certainly think conflict resolution mediation, can I have a friend in California who's a lawyer here in Massachusetts, and she's just doing general conflict resolution mediation. You know, and you may know her, Heidi.
Rachel.
And that's fine, but it's not so targeted.
Yeah, I think that's right. And the other thing is, I've certainly done many mediations that have actually been, you know, interstate and international, but the divorce itself is taking place in Massachusetts. So
Right.
that's a medium that I've used. I mean, this year alone, I think I've done mediations in China, in England, and in Qatar, with one party being in those places. So, you know, really interesting. But, you know, we're all doing it now, right?
Well, great. Thank you to the both of you. Before we close out, if anybody else has any other questions, feel free to raise a hand, put something in the chat. Encourage you to download, if you haven't done it already, to download the slide deck that Heidi and Jen spent so much time on. And just there's several people on here that are giving practicums, have given practicums. There's a tremendous amount of work that Heidi and Jen, you put into this. So thank you very much for all your time and effort. And it was very educational and brought great value to all of us.
Great. Well, thanks
everyone.
for hosting us.
Great. And it looks like maybe one last question came in from Nancy Weissman. Probably that one's for you, Jen. Do you see that?
No, I can't see anything.
Okay, got it.
Are you all comfortable
Nancy,
with
so Nancy writes, are we all comfortable with consideration for post-nups based on the Anson case?
Well, I think the Anson case talks about the idea, you know, the consideration there. She had waived any interest in all of the Florida assets, but the court talked about consideration and what was sufficient consideration. And in that case, they thought she had what she needed. I think they negotiated the post-nup with her getting a couple of $1 million and waiving, you know, her rights, you know, in terms of anything else. But when the court looked at, was it enforceable? What were the factors at the time it was executed, and what were the factors at the time it was, enforced? The court there thought, you know, the consideration rose to the level of, yes, it's fair and reasonable. It obviously was a very different than a Section 34 case or division that she would have received, but the court said, you know, it's good enough.
Great. Okay, thanks to everybody. I'm going to close out the meeting, and thanks again to Heidi and Jen.
Bye, everyone. Be well. Be
For
safe.
coordinating it and for moderating. Thanks very much.
Thanks, Jeremy.
Bye. Bye, Lynn.